In this case, I begin with a word of caution. This matter involves proceedings before the Pennsylvania Lawyers Fund for Client Security Board and encompasses confidential information. For this reason, the pleadings in this matter have been sealed. The parties should confine their arguments to the legal questions presented without disclosing confidential information. Moving on to those legal questions, we allowed argument in this matter to consider whether Pennsylvania Rule of Disciplinary Enforcement 504E permits a covered attorney to subpoena an audio recording of a board meeting. In addition, we are interested in hearing argument on whether due process rights may be violated when such a subpoena is determined to be invalid. Please proceed.
Good afternoon, Your Honors. Again, Yount, representing myself pro se in this matter. From the start, I just want to make it clear that this is a disciplinary action, and just my observation, I don't know everyone in this courtroom, and I want to make sure that there are not individuals that would be able to hear this this argument. I just addressed that question to see if there are any individuals in the courtroom that should be exited during the process of the argument.
Well, the Chief Justice just began by indicating the court's respect for that issue.
All right, Mr. Yount, it was our intention, in accordance with my cautionary instruction to preserve confidences, that this would be broadcast on PCN. Okay. So I have no way of limiting the argument, limiting the audience for the argument if we proceed with that plan. And again, I would just ask that you confine your arguments to the legal questions presented without disclosing confidential information. All right?
Understood.
Thank you.
Thank you. Your Honors, this matter does involve the question of whether or not a covered attorney under the Rules of Disciplinary Enforcement can subpoena information not from a board meeting but from a hearing actually that was held by the fund, I'll call it, the Lawyers Fund for Client Security. That meeting was held October 19th, 2021, and the focus of that is the rules. What do the rules say as regarding subpoenas to the fund? Under Rule 504A, there's essentially a definition of what is confidential information, what is confidential, and that under Rule 504A, it says that it extends to all documents and things made and or obtained in all investigations and proceedings conducted and or held by the fund in connection with the filing of a claim. And then there's some further, in Rule 504D, there's some exceptions as to when confidential information can be released to certain entities that request it. Under 504E, it says that the rule reads, requests for the release of confidential information by any person or entity other than those identified in the subsection D must be made to the fund through the issuance of a subpoena. I submit to you that in this case, the subpoena that was issued to the fund for the audio recording was issued by any person being the individual that petitioned the court in this case.
Is there any question as to whether there's a transcription on paper of this, or is it simply the audio recording?
My understanding is that there was never a transcript made of this meeting.
Okay.
It is just an audio recording. We did make the request. The request was generally denied, so we went through the subpoena process as provided in Rule 504, and we followed that subpoena process. The only reference in the rules under subchapter E is found under 521, specifically 521C under subpoenas, and that procedural process was followed precisely. So the question.
Yes, I do. It's right here. Thank you. The purpose of the subpoena was to acquire the evidence for use in a disciplinary board matter. Is that accurate? I mean, it wasn't just a subpoena to get the audio recording just to have it. I mean, there was an intended use of it, which was in a disciplinary
There is
board
a
proceeding.
parallel disciplinary
Correct.
proceeding. I will say it's an investigation, not a proceeding, but it is a parallel proceeding or claim handled by the Office of Disciplinary Counsel, yes.
Okay, and in the context of a disciplinary board proceeding, can a covered attorney follow the rules of the disciplinary board to subpoena the audio recording from the fund?
In other words, could the attorney have requested that the disciplinary board, in conjunction with its proceedings,
No,
subpoena?
It's a separate question. I mean, my question is, can the covered attorney in the fund proceeding, when before the disciplinary board, use the disciplinary board's rules that allow for subpoenas of documents?
Your Honor, my understanding of the rule, and it's spelled out under 312 of the Office of Disciplinary Counsel, would apply to that. Can I subpoena under Rule 312 and follow that procedure, which is basically the same procedural process if you read down through
They're
it?
two different boards.
I'm sorry?
They're two different entities.
They are two different boards and they're two different rules.
Right.
The process is virtually the same. You go to the prothonotary of the Supreme Court, you get them to issue the subpoena, the response,
Yeah, but that's a different, so what? I mean, that's like saying I could be in, federal court or state court. The process is the same, but it's not. They're two different entities. So can you use the disciplinary rules to acquire the information through disciplinary board procedures?
I'll respond in with two contentions. First of all, no. My reading of Rule 312 is that you have to have an existing proceeding. The review of, under Rule 213, under Rule 213, if the subpoena is going to be challenged, it's going to be heard by an actual hearing committee. This is under paragraph 4.1, all under Rule 213, subpoena powers.
Okay, I'm confused because, to your knowledge, the disciplinary board does not have this audio recording, correct?
They have indicated they do not have
They
it.
do not have it. So isn't the covered attorney who was in proceedings with the disciplinary board in the best position to make a request of the disciplinary board that they subpoena the fund to obtain the audio recording, which the disciplinary board clearly can do?
So there is not an existing proceeding under the Office of Disciplinary Counsel at this time. There has not been to this point. It's a simple case of being under investigation. It's an ongoing investigation. There is not an open proceeding at this point.
Yeah, to the extent if I can just jump in there, to the extent there was merit to his position in that regard, the D board might not have any interest in the recording, whereas the attorney might. So they might not have an incentive.
I have a question, counsel.
Yes.
All right.
We're here under the Lawyers Fund and their rules. Rule 504 establishes the confidentiality aspect. And we know who is permitted and who's not, and who's deemed confidential. 504E instructs anyone seeking information to utilize a subpoena. Now, that read in conjunction with Rule 521, which is the investigation, specifically 521E, I believe, specifically says that I'm sorry, C3 specifically indicates, that's not it, it's 2. The board, the subpoena is, the purpose of the subpoena is to request a witness to testify at such hearing. Following up on Justice Donahue, it appears, and correct me if this record is wrong, that this is this proceeding has ended. You're now trying to utilize the subpoena that's requested for a witness to be used pursuant to the rule so that it can be obtained for use in a separate potential proceeding that may occur, as opposed to waiting for that occurrence and obtaining it pursuant to its rules. Am I correct on that?
That's absolutely correct.
And share with me, how then do we overcome the hurdle that there's no proceeding to issue this subpoena? There may be a docketed number with the investigation by the conduct board, correct? Disciplinary board.
That's correct.
But
Maybe.
you're utilizing the subpoena based upon the fund investigation that's concluded.
That's correct.
And the fund permits only a subpoena for the issuance of witnesses, which is moot. So tell us how you get what you want with nothing before us.
All right, so there's a lot to unpack there in your question. First of all, the reason we proceeded under Rule 504E, let's say, where it says that any person or entity who is requesting information or these confidential information from the fund must do so through the issuance of subpoena. All right? By the way, 504E, if you read that with 504A, and it defines all of the confidential information and basically defines what it is, and then under 504D shows that there's no mention of the issue being moot. This is a subpoena for information that the fund has in their possession. There's no limitations, there's no exceptions. It's ultimately right now, theoretically, not theoretically, in reality, there's other confidential information by the fund, even though the fund's current proceeding is closed, per se, that the other entities under 504D can still request information and get. So it doesn't matter under the rules whether or not the actual proceeding is closed at this
Counsel,
point.
correct me if I'm wrong as well. I follow your argument, and I found it interesting that 504D, permits Office of Disciplinary Counsel or its board to have certain confidential information, but not a covered attorney. So, as unfair as that may appear, that's how the rule is read. So, again, I'm trying to see how you have an opportunity to obtain this confidential recording in this realm when you have the exact opportunity should disciplinary counsel file a complaint against it.
Office of Disciplinary Counsel. Well, again, and not to reiterate, under 504, there is a very specific path by which you can request information. Certain entities under 504D, and I realize obviously that the covered attorney under that definition can't just request it and it be provided to them. But under 504E, anybody else, any person, to me sounds like any other person or entity can request it, and if they do, that is done through the subpoena process. The only subpoena process is spelled out under Rule 521C, and we followed that process.
Well, counsel, let me push back with you a little bit on that. Sure. I think you're making your argument a little bit more complicated than it needs to be. 504, I can see why you're reading it as extending to any person other than what is otherwise covered in there. Any person other than the Office of Disciplinary Counsel, Disciplinary Board, or its committees. It says, the provision E says, request for the release of confidential information by any person or entity other than those identified in subsection B must be to the fund through the issuance of a subpoena. Now, again, confidential information is not witness testimony. Confidential information is broader than that, and so I'm not sure how, to help your argument out, how 504E can be limited only to witnesses when confidential information by subpoena could be other than witnesses. It's broader. So I'm not sure you have to link 504E to the later subpoena provision, which deals with witnesses. I think 504E may stand on its own, that you can get a subpoena to get confidential information. Not witness testimony at hearing, but confidential information. But the big problem I'm having with your argument is the other point that Justice Doherty raised. There is no proceeding pending against the covered attorney in this case. Nothing. And you cannot walk in, to my knowledge, to any tribunal in Pennsylvania, whether it's a court of common pleas, an administrative agency, or any board, in the absence of a proceeding, and just say, can you just give me a blank subpoena so I can get information? And that's what you're basically saying is this provision authorizes anyone at any point in time to come in and get a blank subpoena from the fund, no caption, no nothing, and get confidential information.
Your Honor, in response to that, I mean, perhaps I am overcomplicating it, but under 504, there was a current proceeding when we got the subpoena. There was a current proceeding with the fund.
Agreed.
Yep.
But there isn't now. So the question, and the remedy you want is for us to order the direction of the issuance of a subpoena in a case that no longer exists. And my problem is, it sounds to me like, regardless of whether this took too long, maybe you could have sought a stay of the fund proceeding to have this decided, but it's over, it's done, it's kaput, as we say. Why isn't then this issue moot? There's no proceeding pending under which any subpoenas could be issued. And if you want this information at some point in time, you have to wait till there's a proceeding, in which case you can have a subpoena issued.
If I could push back on that just a little bit, under Rule 504, under D, the authorized agencies, the Judicial Conduct Board, the federal courts, the law enforcement authorities that basically can request this, there is no limitation on their request being that there has to be a current proceeding. In fact, there's no current proceeding with any of the entities listed under 504D. So to extend that into the full rule of Rule 504, any other entity or person can request it. The fact, the requirement that there has to be a current proceeding is not required under Rule 504
So
at all.
anybody, I could walk into the fund tomorrow and ask for a subpoena for confidential information.
Under the rules, yes, absolutely. There doesn't have to be a current proceeding. You, in this case, you would be a court.
No, I'm talking about me, personally.
Well, I presume that it would be denied, and if you wanted to pursue it further, it would be appealed, and that's where we are today. It was denied, and we are here today. So can any other person, that's what the rule says, any person or entity other than those identified must go through a subpoena process.
Isn't the colloquy you just had with Justice Brobson suggestive of the appropriateness of Rule 213 in lieu of the rule that you're citing? In other words, the fund matter ended, and now there may or may not be anything going forward in that other realm. So, in the eventuality that it were to go forward, the attorney involved could avail himself or herself of Rule 213, and then if the fund were to object, then that could be litigated. You know what I'm talking about?
Sure. Yes.
Okay. So why isn't that the proper track for this to be on, rather than looking backward at a fund proceeding that ended?
Your Honor, I'm-
No, let me just say one more thing, I'm sorry. I understand if you're concerned about the disappearance of evidence or the recording being deleted, then, you know, that would, I suppose, be another matter, but we haven't seen that in this briefing, I don't think. Maybe I missed it. And presumably, one could seek preservation. But putting the preservation issue aside, I don't see why the 213 isn't the right mechanism.
just to clarify, you are referring to Rule 312?
Yeah, Rule 213, PARDE 213, which addresses subpoena power in disciplinary proceedings, gives both ODC and the attorney, quote, "the right to summon witnesses before a hearing committee or special master and require production of records before the same by issuance of subpoenas," unquote.
At any stage in the investigation.
Right? So if the ODC decided to go forward, which we don't know, right? If ODC decided to go forward, you could immediately issue that subpoena, and then if they want to fight it, fight it.
There are some concerns in this case with evidence, testimony. It's already been greater than 2 years since this process started. The hearing that we're seeking the audio recording of, held by the fund, was over a year ago. Witnesses disappear, memories fade. That is my concern, and Office of Disciplinary Counsel,
If I'm understanding the mechanism of Rule 213-1, there's no production of records until a hearing committee or special master has been put in place, period, because the documents are produced to the hearing committee or special master. So what you're left with, or a covered attorney is left with, knowing that there is an investigation going on, you're left with the good graces of the Office of Disciplinary Counsel, who have the right at any time to request the production by subpoena of these documents. And if they ask for them and then they get them and you're willing to pay for copies of it, then you will get them. But, I mean, the covered attorney / attorney who's being investigated by ODC has no independent right to do anything, even though under the rules of the fund, ODC is not constrained by the closure of the fund matter, because they have access at any time. So your argument is, if they have access at any time, we can't read subsection E to be subject to a mootness requirement. You have to read it impar materia. ODC has the right, even if the matter is closed, to get the documents. Therefore, any other person at any time would have a right to subpoena. Is that accurate?
That's accurate.
Well,
Yes.
213A1 provides, quote, "at any stage of an investigation, both disciplinary counsel and a respondent attorney shall have the right to summon witnesses before a hearing committee or special master and require production of records before the same by issuance of subpoenas." So if I was a lawyer being investigated and I knew that there was this fund recording out there, I presumably would issue a subpoena immediately, and then if they want to fight about it, we would litigate that in front of the committee.
But you couldn't litigate it until there was a hearing committee or special master before whom
Well, since the rule says at any stage of an investigation, that suggests that it's any stage, and they'd have to convene a committee.
Yeah, I think from looking through these rules pretty closely as we're doing, you can see that there's some ambiguity there. I read Rule 213 and that whole section. If there is, at any stage, yes, using Rule 213, you can issue a subpoena. It's virtually the same procedural process, but then it's reviewed by a hearing. Right now, there's not a hearing committee. I mean, one does not exist. It might be 10 years from now before one exists, theoretically, hypothetically. Could be 10 years. Witnesses are dead in 10 years. Right now, We don't have that option if you read those rules together on 213. If I were to do a subpoena, they're gonna have to open up a claim, they're going to have to put a committee together and start an investigation and start the proceedings. That's not the position of the OGC, that's not where we are procedurally right now. It's just an investigation. Yes, under 213, the first part of that, at any stage of an investigation, period. But if you're gonna read the straight readings of 213, I think we also have to look at the straight readings of Rule 504E that says any person or entity can go through the subpoena process. It doesn't matter what stage of the subpoena process, whether it's moot, we're looking for information to use for some other third outside purpose. Under 504D, it's an outside purpose that these other entities can request the information. Any other purpose, or any other person or entity under 504E, doesn't matter if it's moot, if it's current, it's not. It's for an outside purpose. That is why we've issued the subpoena. It's for an outside purpose. It's not for the current proceeding, which is now closed by the fund. A strict reading of the rules allows us to do that.
Mr.
In
Yount,
fact,
I think we have your argument. Let's hear from Mr. Daly.
thank you.
And Mr. Daly, I will caution you, as I did at the beginning of this argument, not to disclose any confidential information in the course of your argument.
Yes, thank you, Your Honor. May it please the court, Michael Daly on behalf of the Pennsylvania Lawyers
microphone
Fund for Client Security. Is that better? Your Honor, I feel like I'm going to get a lot of the same questions that Mr. Yount got. To clarify, Justice Weck, to your question, the board does have a recording. It's preserving the recording. Mr. Yount's counsel, when they had requested it, preserved it. So the recording is still preserved. Certainly in this case, I mean, I would anticipate that if the other proceeding goes forward, that there probably will be another subpoena coming under the different rules that we've talked about here today, specifically Rule 213.
How long is it preserved? Do you have any idea? Is there a time limitation?
For this one, I would assume that they would hold on to it until, I'm assuming the disciplinary matter's done, given that, you know, this has been an issue and has been raised. To give you a little context, this was the first hearing that the board had done in approximately 5 years, and they do about 200 claims a year. So this isn't something that comes up that often. The reason it's when they've had these recordings or had these hearings, and which are very few and far between, is they're recorded is so that the counsel to the board and the executive director can help them to prepare a summary for the hearing committee that hears it in case they have any questions in making their award. So for this case, we would hold on to it. I mean, I kind of view it as almost, you know, it's like holding on to something when, you know, there's a threat of a legal action or a subpoena.
Mr. Daly, why did the fund turn down the request for records? Why did you deny the subpoena?
The subpoena was denied because, you know, we look at Rule 521C2, which says that, you know, while the board can subpoena documents or witnesses, that for a hearing that the subpoena of the attorney is limited to witnesses only. I mean, it's not, you know, you can't get a transcript or other internal fund documents. Again,
of course, that rule doesn't speak to the circumstance that the fund records these things, which strikes me as kind of peculiar that they record it but won't provide it. But I guess that's not of any moment, because you would agree, would you not, that right now this attorney could, under Rule 213A1, send a subpoena to the fund, and if the fund wants to oppose it, they can oppose it, and the D board is going to have to convene a hearing committee to adjudicate that. Do you agree with that?
yes, Your Honor, and that's what it seems like, as Mr. Yount pointed out. You know, 213, the first two provisions seem a little different because, you know, if there isn't a hearing committee, but it does appear that reading A1 that if there's some request that if the board either appoints a hearing committee or might more likely may just appoint a special master to hear that matter, and that it could get a subpoena, and certainly, and that would handle, address the due process issue, as the Chief Justice mentioned at the start, which the court's concerned with. And in that case, yes, if there was some reason to litigate that, it would be before a hearing committee or special master. I think there's one level of a right to appeal within the disciplinary board, and then that's it. So,
Counsel.
yes.
I see that you're arguing, you've been arguing under, what was it, the 504D, was it that you argued, or was it, what was it your position that you denied the request?
521C2.
521. However, under 504B, it specifically indicates under confidentiality that the fund, after an award is approved, which has occurred, may disclose the following information, and it's talking the name of the complainant, the covered attorney, the amount awarded, and a summary of the claim. That, to me, is a copy of what the board is using to write up its opinions. So now, why are you in a position that you may not provide it to them in the fairness of due process, knowing that instead of preserving it, you provide it to counsel? I guess the question is, so why do you not now lean on your own Rule 504B to say we may now provide a copy of the recording to counsel pursuant to what we're allowed?
Well, because 504B states that, as Your Honor mentioned, the name of the claimant, if permission, covered attorney, amount claim, amount awarded, summary of the claim if needed.
But it's all within the tape. So I guess in the pursuit of due process, you're saying that we, the fund, want to tape the recording to benefit us in our opinion and in questioning anybody or internally. And yet we, the fund, will not provide it to a covered attorney, but we would give them everything else other than the testimony that caused the basis of the claimant, the basis of the covered attorneys, the claim, and a summary of the claim, which to me a summary of the claim would be what transpired, what evidence was introduced. So I'm having a hard time in essence of due process, while you as an arm of the court, as a fund, would not share this information with the opposite side when you want to keep it internally for yourselves.
Well, again, first off, Your Honor, and my understanding is that when the board makes an award, that although it says summary of the claim, there's no opinion or findings of fact or anything along those lines. That's my understanding how that's done.
But I appreciate that, Counselor, but I guess the question is, you're indicating that you have a summary of the claim via a recording for internal purposes, but you will not share it with the covered attorney, based upon what you're arguing was 521E as opposed to 504B, and I'm asking you, why don't you share it pursuant to 504B?
Well,
it meets all the criteria. It's after the award. You may do it. It would be the fair thing to do. I guess the question is, who are you trying to protect, or what are you trying to protect by providing counsel a copy of a hearing that was against them?
Well, first off, Your Honor, the recording is more of just a summary of the claim. I mean, it's the whole testimony. Plus, part of the recording may involve internal discussions between the hearing committee members. So, number one. Number two, that these hearings are not, although they record them for internal purposes in reaching their decision, they're not hearings of record. I mean, they're informal hearings. They're not of record. There's no appeal from them.
But they're used by you guys. I apologize. They're used by your own internal purposes, but you're saying we won't share it for his internal purposes. How's that fair?
Because, Your Honor, there is, and I'm sorry, if I may just clarify, which internal purposes of the covered attorney? You mean for the disciplinary matter?
Correct.
Well,
so is it your position that you and your staff or your people have a right to the process or the hearing for whatever purpose you so deem appropriate, but you're going to preclude the covered attorney, the focus, he's precluded from having the same document you are? And if there's internal discussion, that can always be erased, I would assume.
Well,
or transcribed and redacted.
well, number one, Your Honor, I mean, again, once, and what has happened in the past when there's been hearings is that actually after the summary is prepared, that the recording is not kept, because again, these are not of record. This one was kept because there was a request for it, and we understood with the subpoena and obviously the issues involved. So the fund isn't, you know, once an award is made, the fund isn't keeping these for its internal purposes.
No, but I think you're missing Justice Doherty's point. I thought the Chief actually brought this point up, and you didn't really answer it. We're kind of putting aside the rules for a moment,
Okay.
right? Let's put aside the rules, because the rules deal with subpoenas and process and things like that. This was an adversarial hearing, correct?
Yes,
quasi-judicial-
it's a quasi-judicial.
Quasi-judicial proceeding.
There's
right?
testimony, there's opportunity to cross, to give statement. It's informal, but yes.
Well, due process generally requires notice and opportunity to be heard, but the level of due process depends on the nature of the circumstances. But this was a due process hearing, a notice and opportunity to be heard, correct?
Correct, there was notice, right, was provided. And if I just may say, Your Honor, is that, you know, initially, as I mentioned, there was an award back in, I believe, the summer of 2020, an initial award.
Okay.
Apparently, Mr. Yount, I believe, then got counsel, who then, you know, asked for reconsideration. The board reconsidered it based on, you know, questions I think the board had. They decided, let's have a hearing, like I said, which is pretty rare. So we're going to have a hearing on this date.
Well, you're going to have a hearing, and the hearing has sworn testimony, cross-examination, and you created a record. There were documents, and there was a hearing.
No documents are admitted into evidence. There's no
Are there
record.
documents that the board considered, or that the fund considered?
My understanding in this provision is that documents were, and let me say, it was done by Zoom. So this was done by,
Mr. Daly, look, the problem I'm having is you're getting into the weeds. And really, this is simply, these questions are fairly straightforward. This was a hearing. This was an adversarial hearing, correct?
yes,
Would you consider it was an adversarial hearing if the claim was being filed against you as an attorney? Would you consider it adversarial?
yes,
Okay, so it was an adversarial hearing, and there was evidence that was brought out in an adversarial hearing, correct?
correct,
Okay, and there was cross-examination and sworn testimony, correct?
correct.
And the adjudicator in this case created a recording of that hearing for what you say internal purpose of adjudicating the claim.
Correct.
Okay. Where in the general world of either administrative law or common law or criminal law or civil law is that record, that recording, not given to the defendant?
Well, again, Your Honor, it's the board's interpretation of the rules.
I'm not talking about the rules.
Okay, well,
I would put the rules aside. Where in just the notion of creating a record that is available only to the adjudicator, not given to the defendant, not given to the plaintiff. The adjudicator says, yeah, we created a record, but no one gets to see it but us. No one can challenge our finding because we don't give access to the record. We're certainly never going to give it to the defendant, so he can't or she can't challenge us. Where does that happen?
well, I don't know where it might happen, Your Honor, but I think when you look at the purposes of these hearings, I mean, so you have an instance where, you know, the purpose of the hearing, like I said, it's very rare that these hearings happen. And when they do happen, and then, so.
Well, that might explain why we've never dealt with this before.
Counsel, can I just follow up on that and maybe help to answer Justice Robson's question? I don't know, maybe I'm understanding this, or I have a lack of understanding, but I think the reason that nobody is given a copy of this recording is because there's no right to appeal.
That's correct. There's no right, there's no judicial review.
Which is unheard of in our, general course of events. So the answer is we don't give a copy to anybody because there's nothing to do with it.
Correct.
You can't appeal it. Nobody gets to look at it. This is just the end of the line right here. So why give a copy of anything to anybody? Is that the answer?
And I think that goes into it, Your Honor. Again, since there is no appeal, there's no review of it. And again, most of these matters are decided on the papers. I mean, between a covered, claim
Which
comes.
is a whole different issue. But it's a whole different issue, but, one that frankly, I was sort of taken aback by. But if all of that is true, then why does ODC get the copy of this if all they have to do is ask for it? I mean, where is the fairness in that? Because the only place that this can have any effect at all is if in a case like this, where the covered attorney says, that recording contains exculpatory evidence, and I want it because I'm going to be investigated. Now, ODC gets to see it if they want to. All they have to do is ask. I mean, there's inherent imbalance, I think, is what Justice Dougherty was talking about earlier. There's an inherent unfairness involved in that scenario. Covered attorney who has no recourse from a finding of the fund isn't even entitled to a copy of a recording with exculpatory evidence contained therein, where ODC gets to see it if they want to. I mean, but that's how the rules work, is what your answer is going to be, correct?
That's how the rules are, yes, Your Honor. That's what they state. And of course, as we've talked about under Rule 213, within the disciplinary proceedings, certainly the attorney has a lot more ability to obtain these records.
I
Mr.
just
Daly,
don't-
does the covered attorney get to be present at all phases of the hearing?
I believe so, Your Honor. Yes. Again, I know this one was done by Zoom. I believe there was a number, in addition to the claimants, there was a number of witnesses.
So the covered attorney knows what's on the audio recording, he just wants a copy of it for his future use?
Correct, and it is announced before the hearing that a recording is being made for internal purposes, and I understand the justices may have an issue with the internal purposes, but that is announced, that if for some reason there was to be an objection.
How would you know that? How could you prove that if it's not provided so that it could be argued against you?
I'm sorry, Your Honor?
If they want to object it or make that a legal issue, how do you know that if it's not, it's documented only for you,
Well,
not for him?
Well, I mean, the attorney could at the time make an objection to that if they wanted to.
I'm
And
still trying to find out your basis. Let's remember that your fund was created by this court in
Yes.
1982 for purposes of helping clients.
yes,
You carry the imprimatur of this court. I'm really trying to gather, other than the rule which gives everybody and anyone a copy, but for the covered attorney, for whom the focus is, at their request. And you're basing it upon confidentiality and subpoena. But I still haven't heard you say who you're protecting. The client, you, or the covered attorney, or is it you're just playing, I'm not giving it to you because I don't have to?
well,
Which, at least from our position, when we go back, rules are changing.
well, and certainly, Your Honor, I mean, it is in your prerogative to review the rules, and yeah, so,
As attorneys,
yeah.
how is it, who are you protecting and why?
Well, I mean, it protects the claimants because it's confidential. I mean, and it protects the covered attorney as well. I mean, if anybody could come in and request a fund subpoena, which we don't think is the right reading of 504E, we think that refers to subpoenas from other tribunals, other jurisdictions. If anybody can come in and do that, then the strict confidentiality rules that this court put in place in the rules, it goes against those. I mean, it opens it up to more. And, quite frankly, the hearings don't have to be recorded. I mean, there's no requirement. In fact, the regulations of the board, I think it's 3.6D maybe, say that, there's no stenographic record has to be made of
Are
this.
claimants, when they come before the fund in a hearing, are they advised that their testimony will remain confidential?
I don't know that, Your Honor. I'm sorry.
Okay, do they, in your view, have some expectation of confidentiality?
I believe, and let me go back, and certainly we could supplement this. I believe in the claim forms, which are available on the board's website, that there are confidentiality information, because there are immunity provisions, civil immunity provisions, unless some of those confidentiality provisions are breached.
So that could be a reason why you don't want to turn these over.
Yes.
There's in effect a litigation hold on this, right? Because a letter was sent and there's no spoliation. Speaking of spoliation, there's no spoliation risk here, right?
Yeah, that's what I would, exactly. We view it as a litigation hold.
And so, in your brief, you said on December 7th, the Funds Board affirmed the initial award and paid X dollars to the claimants. Petitioner has since satisfied the principal obligation of the fund of X dollars as well as the Y dollars interest obligation. Hence, the fund proceeding is completed and closed. So the Rule 213 subpoena could ostensibly be sent and then litigated if there's a dispute. Is that correct so far?
Correct.
Okay. Secondly, you said in response to some justice's question that there is no appeal. So if petitioner had not satisfied that obligation and had said, I don't agree to that, presumably he would have to have had some recourse to us or some other tribunal. It's not a matter of grace. I mean, in other words, put it this way. The fund paid the money out of the fund, but then it looked to the petitioner to satisfy that. Am I right?
Yes, under Rule 531, we're getting
Okay.
into.
And what if he said, I don't agree? There has to be, maybe this goes to Justice Doherty's point about the rules need to change.
There
So
is
the
no
piece I'm
recourse.
missing.
Am I correct? There is no
There is, I mean, the rules specifically say there's no review. I think it's 502A.
Not only that, in a disciplinary proceeding, the award from the fund becomes a penalty that's imposed against the now attorney in the disciplinary proceedings, and he or she cannot be readmitted to practice law until that amount is paid.
Right, so my understanding of the consequences of an award under 531 is, let's say there's a reward $10,000. There is interest that will accrue, so interest will accrue on that. But the only time it really comes into effect, Justice Donahue, to your point, is if you have an attorney who's suspended or needs to be readmitted, that has to be satisfied. But if otherwise, you have your license and everything's fine, technically you could just let it sit there and accrue interest.
How would that happen? How would that happen? If somebody goes before the fund, is found to be a attorney who engaged in, what's the language, not misconduct, what's the phraseology under the funds?
Oh, I think they use defalcating or something along those lines. Yeah.
Dishonest conduct
Dishonest conduct.
by a covered attorney. How could dishonest conduct not be the subject matter of a disciplinary proceeding?
Oh, it can. Yeah.
Well, when would it not be?
Right.
I
When
mean, you're
certainly.
suggesting a
Yeah.
scenario. You're suggesting a scenario where somebody is found to be a attorney who engaged in dishonest conduct, who doesn't find him or herself before the disciplinary board.
Well, my scenario was more of the consequence of not paying would be if you got to the point where your license was suspended or you needed to be readmitted. If you go before the disciplinary council and it's a private reprimand or a public reprimand or something along those lines, then you still don't have to necessarily satisfy the fund. Now, it may be part of disciplinary council's negotiations, possibly, which obviously doesn't involve the fund, but.
Okay, so now I get it. So the due process solution is that if the covered attorney says, no fund, I'm not paying you back for this, then it goes to ODC, they pursue the person, and ultimately we can see that, right?
Well, they may pursue
No?
the person anyway, even if they don't pay. I mean,
They would be pursuing them for the underlying charge.
for the underlying conduct.
Right, but I guess I'm back where I was. I'm still puzzled because that's a deprivation of property without due process if there's no appeal right.
Well, not only that, it may be unconstitutional because you have, in Pennsylvania, under the Constitution, you have a right of appellate review for any administrative agency
Right, there's that.
adjudication. And this seems to me to be very adjudicative without a right of appeal.
And various of the rules say there is no right to appeal.
Directly in the rule, yes.
Directly, the rule
So we might
says
have
there
created
is
an
no right to
unconstitutional-
appeal.
Whoops.
Yeah.
Aren't we excited we took?
I mean, yeah, I didn't want to say anything, but you're right, Your Honor. So there is no review. I mean, I don't know if somebody could somehow try to bring a King's Bench petition or
Yeah.
something.
Well, that in
Correct
theory,
me if
yeah.
I'm wrong in my understanding of this rule, and if disciplinary proceedings are commenced, and there is found to be no violation of the rules of professional conduct, that has no effect on the award by the fund against the covered attorney.
It has no effect on the award to the extent that, let's say that finding was made afterwards, and frankly, I don't know what the fund would do in that case, if they would, look to the attorney to reimburse that, so.
What I've rephrased is coming directly from the rules. A finding of no violation of the rules of judicial conduct has no impact on the award made by the fund.
Rules of disciplinary, professional conduct.
Rules of professional conduct.
Rules of professional conduct, yeah. And that may be depending on whether it was before or after. If ODC looked into it before there was a claim, and then, so.
The due process in terms of owing the money, paying the money back, can be resolved, can be adjudicated before the disciplinary board. It seems to me that the whole and we may not have any constitutional problems here, Justice Robinson, I hope. It may be that since the whole purpose of the fund is to make clients whole who have been injured by the conduct of a lawyer, that is a mission that the court has undertaken through this Lawyers Fund for Client Security to recompense clients who have been injured financially by an attorney. So it doesn't seem all that unusual to me that there's no appeal from that process, because there is going to, in all likelihood, be a disciplinary process
It
afterwards.
seems highly unusual to me, so we have a little bit of a difference here.
Yeah, can I-
on-
I didn't say it wasn't unusual.
Can I just follow up
said
the
that the purpose is to undertake a mission to compensate clients who have been damaged by an attorney's conduct.
No,
That's
no
a
one
different
questions-
mission than
I don't think
an-
anyone would question the validity of the purpose.
use of it.
But obviously, I think what's been identified here is a severe due process problem, when we apparently have said there's no right of appeal, when that's totally strikes me as unconstitutional.
And if we
Well, but
didn't
appeal
see-
from what? Appeal from compensating clients, what's the problem?
The adjudicator-
Appeal from
problem is
his disciplinary
If the fund-
action, that happens in the next
No,
stage.
no, if but I mean, Attorney Duff Daly just said, in theory, there may never be a disciplinary proceeding, or at least if there is, it could be a separate amount and separate bill, so to speak. So suppose the fund says, Attorney Smith, you owe $10,000. And unlike in this case, Attorney Smith said, go pound salt, forget about it, you're not getting it. And then our rules are saying, guess what? There's no appeal. So that is obviously infirm. That's obviously null.
Mr. Daly, what does the fund do if an individual covered attorney does not pay? There's no action against him, right?
That's my understanding, correct.
Yeah, that's why I'm not seeing a due process violation. The due process issue arises if he's compelled to pay it, which would happen through a disciplinary
No,
proceeding.
the due process violation would occur if the officer, if it's requested by the disciplinary council, which means a record is created and it's provided, and it's targeting a covered attorney who is not entitled to the content of which is now being provided to the potential prosecutor.
But he would get it at that point, right? If the covered attorney has a proceeding before the disciplinary board, Office of Disciplinary Counsel, and they request an audio recording from the fund, at that point, the covered attorney is going to be entitled to receive it from the disciplinary board.
Assuming they request it. If it's containing exculpatory evidence, they may not want it. They may just want to have a witness. And we don't try people by surprise. You
But we don't have
open
that
process.
case here. We don't have that case here because there
You
is
have
no
the derivative of it
disciplinary,
here.
we don't have a disciplinary proceeding here.
You don't represent the disciplinary board by any chance, do you?
Not in this.
Not in this one, no.
We'll resolve this back there, but
Yeah, well, I appreciate that, Your Honor. I mean, obviously, there's a lot of administrative questions,
is
but
there anything you'd like to say in conclusion?
just that the hearing committee was correct in the
You
subpoena
just want to
ruling.
get out of here alive.
Thank you, I appreciate it. Thank you, Your Honors.
Thank you both. Mr. Minner?